You are driving through Los Angeles just like you have for the last 10 years, and suddenly, you get pulled over and handed a massive fine for something that was not even illegal last month. California's 2026 vehicle code changes are officially active, and they are catching millions of drivers completely off guard with penalties that are absolutely brutal. Right now, Highway Patrol and local police are writing tickets for violations most people do not even know exist yet, and these new laws are specifically designed to drain your wallet. Your insurance rates could spike, your car could be impounded, or you might even face a suspended license for everyday driving habits that you thought were perfectly legal. The curiosity you should have right now isn't just about how fast you're driving, but about the hidden legal traps the state of California has quietly installed in your daily commute. Why is the state suddenly allowed to mail you a $200 ticket without a police officer ever pulling you over? What happens if your phone battery dies while a cop is standing at your window? Subscribe to Tax Hack Pro. We follow the money, the municipal codes, and the legislative shifts that the mainstream media refuses to explain in plain English. Hit that subscribe button now so you can protect your bank account and your driver's license before your next trip down the 405. Before you get behind the wheel tomorrow, you need a forensic audit of exactly what changed in the California Vehicle Code and how these new enforcement tactics are going to hit you financially. Number 1. California now requires immediate digital or physical proof of insurance, and the fix-it grace period is virtually gone. Starting in 2026, California Vehicle Code Section 16028 was aggressively updated. You are mandated to have proof of insurance accessible the exact second an officer asks for it during a traffic stop. The law technically allows you to show this proof on your smartphone, but here is the massive financial trap that most drivers miss. If your phone is dead, if the screen is locked and won't read your face, or if you simply have bad cell service and the insurance app won't load, you're getting a ticket. Officers are instructed to allow reasonable time for you to pull up the document, but the state deliberately left the word reasonable undefined. That means it is entirely up to the mood of the officer standing at your window. The penalty for failing to provide immediate proof ranges from $100 to $200 for a first offense, and under Section 22,651, they can legally impound your vehicle on the spot. Even if your insurance is fully paid and active, you will face these penalties simply because the PDF wouldn't load on your screen. You cannot text or email the proof to the officer later. The statute demands immediate roadside display. To avoid this trap, you must download your insurance card as an image and save it directly to your phone's local photo gallery or keep a physical printout in your glove box. Do not rely on your insurance company's app when an officer is flashing a light in your eyes. Number 2, distracted driving penalties have tripled, and the definition of hands-free has been completely rewritten. Vehicle Code Section 23,123.5 was dramatically strengthened to turn your smartphone into a massive financial liability. The base fine for a first offense jumped from $20 to $200, and a second offense will now cost you $500 plus mandatory traffic school. But the real danger is how the state now defines a violation. Previously, you could legally use a hands-free device mounted on your dashboard. The 2026 law severely restricts this. Your phone mount must now be positioned in the extreme lower corner of the windshield on the passenger side or specifically on the dashboard without obstructing any view. If your phone is mounted in the center of the windshield, you are breaking the law. Furthermore, while voice-activated functions are legal, physically touching your screen for any reason while driving, even if the phone is legally mounted, is now a strict violation. Tapping your screen to accept a route change on GPS or skipping a song will trigger a $200 fine. The state also expanded the definition of holding a device. If your phone is sitting in your lap, tucked under your leg, or resting on any part of your body while the car is in gear, you are legally holding it. Even if you're stopped at a red light or stuck in gridlock traffic, interacting with your phone is illegal. California Highway Patrol is now using spotter techniques, where an officer stands on an overpass or acts as a pedestrian to spot phone screens, then radios ahead to a chase vehicle to pull you over. This conviction adds a point to your driving record, meaning your insurance rates will skyrocket for years. If you are realizing that your daily commute is suddenly a legal minefield, you need to subscribe to Tax Hack Pro. We audit the municipal revenue strategies that states use to tax you through citations so you can stay one step ahead of the enforcement algorithms. Number 3. Automated speed safety camera systems have expanded to 25 additional California cities. Assembly Bill 645 initially authorized speed cameras as a pilot program, but in 2026, it exploded into a statewide revenue machine. These automated enforcement cameras do not care if it is a police officer or a machine issuing the ticket. They capture your license plate the moment you exceed the posted speed limit by more than 10 miles per hour in designated safety zones. The registered owner of the vehicle receives a citation by mail, completely circumventing traditional police stops. The financial penalties are structured like a tax bracket: $50 for going 11 to 15 miles over the limit, $100 for 16 to 25 over, and $200 for anything above that. Because these are classified as civil penalties, they do not add points to your license, but failure to pay will result in a hard hold on your vehicle registration renewal and aggressive collection actions. These cameras operate 24 hours a day. If you drive 36 miles per hour in a 25-mile-per-hour school zone at midnight on a Sunday when no children are present, the camera will still flash, and you will still owe the state $50. Cities like Los Angeles, San Diego, San Francisco, and Long Beach are deploying these cameras rapidly. The state is required to post warning signs 500 feet before the camera zone, but if you miss the sign, you pay the fine. The most controversial aspect is that the ticket goes to the registered owner, regardless of who was actually driving. If your teenager borrows your car and speeds, you are legally responsible for the fine unless you submit a signed declaration under penalty of perjury identifying the true driver. Number 4, commercial driver's license holders now face permanent lifetime disqualification for specific offenses. California has adopted aggressive federal regulations under Vehicle Code Section 153,000 that will instantly end a commercial driving career. If you use a commercial vehicle to commit a felony involving controlled substances, your CDL is permanently revoked with zero possibility of reinstatement. There is no 10-year waiting period anymore. It is a lifetime ban. Even more heavily enforced is the chemical testing mandate. If you refuse a chemical test for drugs or alcohol while operating a commercial vehicle, your first refusal is a 1-year suspension. A second refusal means you can never hold a commercial license in California again, even if you were completely sober. When you hold a CDL, your rights regarding chemical testing are significantly reduced. Furthermore, the legal blood alcohol limit for a commercial operator is not 0.08%, it is 0.04%. Blowing a 0.04 results in immediate out-of-service orders, potential criminal charges, and career destruction. Because major logistics and trucking companies run continuous background checks, a disqualifying event means you will never drive a school bus, a delivery van, or a long-haul rig again. In a state that relies heavily on logistics, this law is wiping out thousands of jobs for minor infractions. Number 5. Zero-tolerance oral swab drug testing now applies to all drivers under 21. Vehicle Code Section 23,136 has always had zero tolerance for alcohol for minors, but in 2026, this was weaponized to include cannabis and all other controlled substances. Any driver under 21 who operates a vehicle with even a microscopic, detectable amount of THC in their system faces immediate license suspension for 1 full year. It does not matter if the driver is completely sober and not impaired at the time of the stop. The detection threshold is measured in nanograms per milliliter. Because THC binds to fat cells, it can remain detectable in a blood or oral swab test for weeks after consumption. If a 20-year-old legally consumes cannabis in Nevada on a Friday, drives back to California, and gets pulled over for a broken taillight on Wednesday, they will lose their license for a year if an oral swab detects residual THC. Law enforcement is now widely deploying rapid roadside oral swab tests that yield results in minutes. If you refuse the swab or the subsequent blood test, your license is automatically suspended anyway. The DMV has absolutely no discretion to reduce these suspensions. Parents need to understand that their teenagers are driving under a legal microscope where past weekend activities can result in immediate loss of driving privileges on a Tuesday morning. Number 6, blocking an electric vehicle charging station now triggers mandatory towing and a $500 fine. As California forces the transition to electric vehicles, the infrastructure is buckling, and the state is using aggressive financial penalties to manage the chaos. Under the amended Vehicle Code Section 22,511, parking in a designated EV charging space without actively charging your vehicle will result in immediate towing at the owner's expense, plus a mandatory state fine of $500. The days of getting a warning or a simple parking ticket are over. If you park a gas-powered car in an EV spot, or if you park an EV in the spot but do not plug it in, your vehicle will be towed within 30 minutes of being reported. When you factor in the state fine plus the impound and storage fees, parking in an EV spot will easily cost you $1,000. Even more critically, if you are actively charging your EV but leave the car parked there for more than 15 minutes after the charging session is complete, you are now legally blocking the station and are subject to the exact same towing and fines. Private property owners, like shopping malls and apartment complexes, are now fully authorized to enforce these penalties, and automated sensors in the charging stations are alerting tow trucks the moment a charging session times out. If you want to know how to legally dispute these automated fines and protect your vehicle from predatory towing, make sure you subscribe to Tax Hack Pro. We audit the municipal code loopholes that allow you to fight back against state revenue grabs. Number 7, mandatory rear seatbelt requirements have been extended to all adult passengers. California Vehicle Code Section 27,315 previously mandated seatbelts for front seat passengers and minors in the back. The 2026 update makes it illegal for anyone, of any age, to ride in the backseat without a seatbelt. If an adult passenger in the backseat is unbuckled, the driver of the vehicle receives the citation. The fine is $162 for the first offense and nearly $300 for a second offense. This law has created a massive legal headache for Uber and Lyft drivers. Rideshare drivers are now legally responsible for ensuring that grown adults buckle up in the back of their personal vehicles. If a passenger refuses, the driver must cancel the ride and lose the income, or risk a citation that could ultimately cost them their commercial transportation permit. While this is currently a secondary enforcement law, meaning police cannot pull you over solely for a rear seatbelt violation, will absolutely add this fine onto your ticket if you're stopped for speeding or a broken tail light. Number 8, license suspension periods have doubled for street racing and exhibition of speed. In response to a spike in traffic fatalities, Vehicle Code Sections 23,109 and 23,109.1 have been drastically intensified. A first conviction for street racing now triggers a mandatory 6-month license suspension. A second conviction within 5 years results in a 2-year suspension. But the real trap for the average driver is the exhibition of speed clause. You do not have to be racing another car to be charged under this statute. If you rapidly accelerate away from a stoplight, spin your tires, or purposefully break traction, an officer can cite you for exhibition of speed. The financial destruction of this charge is absolute. The state can impound your vehicle for 30 days on a first offense. On a second offense, the state can legally declare your vehicle a public nuisance, seize it permanently through civil asset forfeiture, sell it at auction, and keep 100% of the proceeds. Specialized task forces are currently monitoring social media to track car meetups, and they are using unmarked vehicles to issue permanent seizures of cars worth over $50,000. Number 9. Bicycle and pedestrian right-of-way violations now trigger mandatory traffic school. California has some of the highest pedestrian fatality rates in the nation, and the state is responding by removing judicial discretion. Under Vehicle Code Section 21,950, if you fail to yield to a pedestrian in a crosswalk or violate a bicycle lane regulation, you will be hit with a $238 fine, and you are mandated by law to attend an 8-hour traffic school program focused specifically on pedestrian safety. You must understand that an unmarked crosswalk exists legally at any intersection where sidewalks meet, even if there is no white paint on the asphalt. If you fail to yield to a pedestrian at an unmarked intersection, you are getting a ticket. Furthermore, driving into a designated bike lane to bypass traffic or make a quick right turn is a strict violation that triggers the exact same mandatory 8-hour class. Number 10. Out-of-state license recognition has been functionally eliminated for new residents. Under Vehicle Code Section 12,502, if you move to California, you have exactly 10 days to obtain a California driver's license. The 2026 update deployed enhanced data sharing between government agencies to enforce this. If you update your address to California residence for voter registration, tax purposes, or to register a vehicle, the DMV's algorithm immediately checks if you hold a California license. If you pass the 10-day mark while still holding your Texas or Florida license, you face fines of up to $1,000. The state is systematically targeting out-of-state remote workers and college students who try to maintain residency in income tax-free states while living in California. If you're caught driving on an out-of-state license after establishing economic residency in California, the financial penalties are severe, and the DMV is strictly enforcing identity verification protocols that make it incredibly difficult to skirt the system. California's 2026 vehicle code changes are not minor administrative updates. They are a coordinated effort to aggressively tax your daily commute through citations and fines. The state is using automated cameras, digital verification, and zero-tolerance mandates to ensure that one simple mistake costs you hundreds, if not thousands, of dollars. Share this audit with anyone who drives in California because the era of the warning ticket is officially over. If this financial investigation opened your eyes to the legal traps waiting for you on the highway, hit that like button right now. This is Tax Hack Pro, and we are dedicated to giving you the forensic data you need to protect your wealth from municipal overreach. Drop a comment below telling me which of these new California laws shocked you the most, and make sure you are subscribed so you never miss an audit. Stay sharp, drive smart, and keep your money in your pocket.